Good afternoon, ladies and gentlemen. My name is Noel Hebron-logan, a final honors 2 student of Rabe College, University of Sierra Leone, in the Department of Law. My responsibility this afternoon is to help with a tutorial which I believe might be beneficial to fellow students that are at the verge of enrolling into the LLB program. However, from the various aspects of the law, I would like to give a tutorial this afternoon on criminal law by giving a preliminary aspect of what criminal law is, and after that I may forge ahead in other aspects of criminal law. This could only be a subtopic, that is an introductory stage to what criminal law is, because a lot of people might get it convoluted based on the fact that when they talk about criminal, a lot of people have different perceptions of what they think about criminal law. Therefore, when we talk about criminal law, it is simple and straightforward. A criminal law is only considered when there is a set of rules, guiding principles, which a state or society have actually affixed to its citizens to abide by it. And in a breach of those duties and responsibilities of the citizens, where there is a breach on those laws, then it could become a criminal. In a simple trend, when we talk about criminal law, they are laws that are put by society or states or the government of a state or the leadership of a state by restricting things that are not supported in that society to be committed or to be done by the citizens. So whosoever might go contrary to those laws, then automatically that particular individual might have committed criminal offense. So when we talk about criminal law, it's a law that is affixed to society by its leaders or by its society towards the citizens by making sure that the citizens obeys the laws of that government. And failure to obey, it automatically becomes criminal. I know criminal ideology has actually been created in so many situations. But I cannot forge ahead in discussing criminal law by giving just a definition of criminal law without bringing to the fore what a crime is, because criminal law goes with a crime. So therefore, there is no standard definition for crime. That should be known by every student. There is no standard definition of crime. But in my tutorial, I will try to give an insight, give a synopsis of what crime is, just for us to have better understanding or to have a clue on what crime is. When we talk about crime, a crime could be divided into four major segments as provided by different philosophers based on their ideas and views that have been proclaimed to show what a crime is. To some philosophers, they limited themselves to explore their ideas on crime by bringing to the fore one of the major types in which a crime could be considered. We consider it to be crime as public wrong. Crime as public wrong, when we talk about crime as public wrong, it is a law that is put by a society, or it is a conduct that is committed by the citizens towards the public, and where that act or conduct might have actually created a default or a breach of privacy, or has actually created problem to the society or effect to the society negatively, then it could be considered as a crime. As long as the acts cause harm or mayhem or problem or wrong to the society, it could be considered as a crime. But without such, where an individual's conduct hasn't any negative impact or effect to the public, then it could not be considered as a crime, as propounded by different philosophers. The next part is procedural test, which is the second part of crime. When we talk about procedural test, this had been an ideology that has been given by different philosophers to say a crime is only a crime when the procedures are followed to the letter. But if the procedures are not followed to the letter, then it could not be considered as a crime. Now, what they are saying here, when it's about crime, it should follow procedure. If it is a criminal offense, then it follows criminal procedure. But if it is civil, then it goes with civil procedure. But in most part of society, we have seen crimes that are criminal, they are done on a civil basis. When people are supposed to pay people a specific amount of money or on in a debt basis, they take them to police stations, which is a civil offense. The individual never stole money from you. He borrowed money from you. And in as much as that money has been borrowed, there hasn't been any criminal. It is civil. When an individual goes to a specific location and steals money from somebody, that is criminal. Then criminal procedure should be followed to the letter. So for procedural test, that is what it is about. That if it's a crime, then it could only be considered as a crime if it has to follow the procedures necessary. That is what procedural test is saying. Then crime as morality. Morality test here is bringing to the fore that a crime is only considered by some religious people in society, that for them they could only consider a crime if it has a moral effect negatively to the society. But if it doesn't have any moral effect to society, then it could not be considered as a crime. Now, under this ambit, I would like to bring to the fore a key case law by giving one major case and one exception to it. We talk about Shaw versus DPP. In the case of Shaw versus DPP, it has to do with morality. This was a guy that was considered to be a PINP. When we talk about PINP, I know there are some other people, they might get it convoluted or confused. But when we talk about PINP, these are people that actually trafficked women. They make money from them. They receive money from those that are making use or going into sex with them. And at the end of the day, they are paid for such service. So in that light, we consider them to be pimp, in which we call PINP. So this was a guy by the name of Shaw. He made a publication by helping out prostitutes to be advertised on a newspaper, so that people that are interested in prostitution or they want to make use of prostitutes could go in search of them through the newspaper, where the phone numbers and every intact informations were affixed to the said newspaper. So it was considered that indeed it is immoral for sure to have done that, because it has to contravene the moral norms of society. So it became a crime. That is where we consider as crime or morality test. We have a supporting case again where we have what we call Knuller versus DPP. Knuller, Knuller versus DPP. This was a guy that engages himself on the same publication as it was done in the case of Shaw versus DPP. Now, in the case of Nula versus DPP, the fact here is the guy believes in gazing. He advertised that indeed it is necessary for men to go into relationship with fellow men, and if possible they should get married, by way of putting down the capacity or percentage of childbirth in society. We know in some aspect of society, like in America and other areas, it is supported for gays or homosexuals to fall in love with each other. But in specific aspects of the society, of in any of the countries that are not in support of such moral misconduct, they are against it. So Shaw made this publication and he was arrested. So, but we all know, however, that prostitution is never a crime. As long as it is done on the privacy of that individual, it is not a crime. But if the conduct or the said prostitution has to contravene the moral conduct of society by allowing people to view and practice from the said immoral conduct, then it has actually become immoral to the society. So it could be considered as a crime. Now, practicality tests. When we talk about practicality tests, it cannot be overemphasized. Practicality test is where an individual commits a crime and it is dealt with, and that individual is being dealt with by law. If you kill, you face the justice, then therefore it has gone with practical. But if you commit a crime and escape liability, then it could not be considered as practical. If Mr. Logan kills somebody, it is always necessary for Mr. Logan to be prosecuted by law and being dealt with severely according to the constitution or the laws or acts of those states. But if out of influence or affluence I commit a crime which is criminal, then I escape liability, then therefore it has not become practical. Even though we realize or we have it at the back of our mind as law students that under the ambit of act of who is convict, act of who is acquit, where an individual is being is being convicted for a crime, he cannot be convicted for the said crime again. And where that individual is being evicted, therefore he cannot be brought to the same court again for the said crime. That is what act of who is convict, act of who is acquit. As long as you are acquitted for that crime, you cannot be brought to the court again for the same crime you have been acquitted for, except if you go ahead committing another. That is for act of who is convict, act of who is acquit. So for the purpose of this, I want all and sundry to realize that you cannot discuss criminal law by bringing to the fore the definitions without elaborating on what crime is, as I have explained in this video, that we don't have any standard definition of crime. But a crime could only be considered as a crime if it follows those four major criteria. One, crime as public wrong, meaning the said crime or conduct of that individual should have a negative impact on the public. It has to do a wrong to the public. If it does a wrong to the public, then it could be considered as a public wrong. So therefore, it will be considered as a crime. Procedural, it has to follow procedure. If it is criminal, then it should be dealt with criminally. If it is civil, then it should be done on a civil basis. Where I'm supposed to pay you, it is civil. Where I contravene the laws of a state, it is criminal. Then criminal procedures should be followed. Then on the ambit of morality, morality is a religious ideology, that there are conducts that are done by people in society, it is purely immoral. So if it is immoral, then it could be considered as a crime. But if it's not immoral, then it is not a crime. That is why I brought to the fore the Shaw versus DPP as a case law for morality, supported by Knula versus DPP as another additional, supporting case to Shaw versus DPP. The last one I said has to do practical. If you do the wrong thing, you should be brought to the court for trial and being dealt with fairly. And where you are convicted, then you cannot be convicted twice. And where you are acquitted, you cannot be acquitted twice for the same said offense. So in a nutshell, this will be a preliminary stage of what criminal law is and that of crime. Thank you all for your listening. And I would like viewers of this video to take key relevant issues that has been discussed in this tutorial as you await another videos ahead. Thank you for your audience.